Hello everyone, welcome to LexTalk World's talk show presented by Clickaway Creators. Today we have Mr. David Marc Lee with us. David is the Associate Director of the firm Focus Law Asia LLC, Singapore. His practice centers around complex commercial disputes and related advisory work, as well as company-related insolvency and restructuring. His litigation and advisory experience include representing companies and HNIs in wide variety of matters, from shareholders to white collar and blue collar crimes. So we'll talk about all of that, but without further ado, let me welcome him to the show. So hi, David, welcome to the show. How are you doing?
I am good, thank you.
Great, good to hear that. Thank you, Arish, for joining us and giving us a pleasure to sort of understand about you today. All right, David. So whenever we generally start the session, our first question always is because we want to set up a context in terms of sort of an interesting discussion. So if you can share or tell us about a complex legal issue that you worked upon recently or in your career so far, and if you can also describe the complexity around it and how you really approached it and solved it.
Sure. One of the things that I found really interesting is actually happening right now, and it's before the courts right now. We've had a couple of preliminary hearings about it, but essentially it centers around whether or not letters of credit, one of the fundamental tenets of the banking system and to ensure smooth flow of cash, essentially in the trading world. It's a really fundamental security document, whether or not that really can be described as your traditional unilateral contract. And that's really important in the context of, I would say, the cause of action of misrepresentation, because the claim that is being brought now is whether or not certain representations that were made induced the bank, which was issuing the letter of credit, into entering into the contract. So that is extremely complex, because letters of credit have traditionally been seen as a standalone sort of individual animal by themselves, sort of a unique creature to themselves. And one of the things that we are trying to do now is to fit it into that framework of unilateral contracts, which everybody knows about, because I think that then that would open up a lot more possibilities for aggrieved banks to say, look, there have been misrepresentations made by a beneficiary of the letter of credit, and therefore I should be able to claim against them. So there are many factors which go into this, many legal ones, but importantly many commercial ones. So one of the things that is really important for any trading house or any business person, I would say, is the knowledge and the security that a bank is going to pay against that letter of credit and that security document. But equally incumbent on that business person is the obligation not to do something illegal, right? So in other words, I'm arguing now, or we are arguing now, the firm is arguing that there's this imbalance between a bank's rights and obligations and the business person's rights and obligations. So I wish I could tell you the outcome, but that'll take maybe about a year or so, because that's going to trial.
I mean, I wish that once the outcome is there, we are again on the show and discussing about that.
Yeah, I would love to be.
David, I also wanted to understand, because letter of credit, we have heard this name many times, this term many times, whenever sort of many scams had happened around the globe. When a scam happens, there is a keyword such as this. So is there a possibility that you can explain what are the loopholes in this process, and how scamsters or the big HNIs can sort of misuse this practice?
Sure. So it's a really specific scenario, but in the case of, say, for example, of a let's say a shipping contract, right? And there's a seller, there's a buyer, and so the buyer appoints the issuing bank of the letter of credit. The bank therefore issues the letter of credit to the beneficiary and says, okay, if you present me with A, B, C, D documents, I'll pay against that credit. Now, typically what happens is that the documents are compliant, typically, right? Because a seller is going to want to get paid. But the problem is when a seller, a seller presents falsified documents, not quite on the level of fraud, perhaps. Maybe there are documents which contain some sort of negligence, and in that case, what would have happened is that the bank would have paid out anyway, but isn't really left with recourse as to recovering payment. So we're not talking about refusing payment, right? So that element of the commercial transaction still goes through because, again, like I said, it's a fundamental tenet of the trading world. You've got to make sure cash flow is there. So, unless there are very specific conditions, the bank's going to pay, right, against compliant documents. But what if the supposedly compliant documents contain, let's say, an innocent misrepresentation to say, all right, there's this cargo, but the seller was misled by A, B, C, D people, up the chain of the transaction, and there is no cargo, right? In that particular case, then what recourse is the bank left with, right? And more importantly, not more importantly, but an additional layer is what if there's an interposed bank. So, for example, an advising bank or a confirming bank. Then there's an additional layer of, okay, who really makes the payment? Who are the representations being made to? But what we're trying to get at here, to make the letter of credit fit into the unilateral contract framework is really to enable an issuing bank to sue for recovery of payment against non-compliant documents from the beneficiary, where appropriate, even from innocent misrepresentation. So then it's incumbent on the beneficiary to then go and say, all right, I'm going to have to go and look to the people who have indemnified me for this purpose. But I mean, what I'm trying to say here is that I don't think that blame, especially or rather liability, especially for such instances where there's a clear non-compliance with the terms of the letter of credit, I don't think that the bank should be left with no recourse.
Yeah, I mean, that's right. We here in India, we have seen a lot of, not recently, but we've seen scams. Our famous scam was in 1992. I'm not sure whether you heard of it. It's called Harshad Mehta scam. Many of Indian viewers are aware of it. It was sort of the biggest scam even till now, I believe, in the share market, and that was really crazy. And there have been a lot of things. So I also wanted to understand about it and how the things work and how the complexity around it actually. Great. Thank you very much for helping me personally and our viewers understand this.
No worries at all.
David, if we are talking about, I also want to talk about the post-pandemic scenario.
Sure.
To you. I mean, in my side of the world, we saw a lot of courts begin moving towards more remote proceedings and availability. And this was, so we have a lot of debates going on that it is sustainable or not. Will this increase, bring an increase in access to justice or not? And is this a question of the structuring of the process? So what's going on there? What's going on in Singapore? I mean, what's after pandemic? Are you guys still in virtual proceedings, or is this a hybrid mode? And what do you think? Is this sort of reducing the justice gap?
So, well, I've been in, since the pandemic started, I've been in trials that are both virtual as well as in person. I've also been obviously in hearings which are in person or virtual. So, but what's happening in Singapore is that typically all the procedural and interlocutory proceedings. So it could be a substantive hearing, but it's not quite full trial. That's all typically virtual now. And so the default seems to be virtual, unless I believe if there's a litigant in person. If there's a litigant in person, in that case, the court tends to like to see the person, at least for the first, 2 hearings or something like that. That's from my personal experience. I'm not sure about other Singaporean lawyers, but we're talking about legal technology improvements to the quality of life of lawyers. Yeah, it's been a fantastic move. In fact, from my understanding, the Singapore courts were actually looking at moving to virtual hearings before the pandemic, and so the pandemic essentially was a catalyst for that change. And it's been wonderful because it means that I don't sit around the courts for another hour or two. Each time I have a hearing to wait to be called into the chambers, but and I can do other work in the meantime. So from my perspective anyway, I hope and I think that virtual hearings are here to stay. Now then there comes a question of whether when the actual litigants, witnesses, factual or expert witnesses need to be in the stand, whether or not it's beneficial for it to be overseas. I think what the pandemic has done, and this movement to remote access to hearings has made the courts a lot more flexible. So the judge himself or herself needs to decide, okay, do I really want to look at this person, and catch their demeanor, what are they like in person? There are some things, that are argued that it's lost over Zoom, or it's lost over any other video conferencing technology. That's up to the judges. I think that you can probably catch what a person's doing or feeling, or their demeanor over video conferencing. But if the judges want to see their body language, I mean, that's fine. I think you asked a question about access to justice, did you?
I'm sorry. Yeah, I did actually. I just wanted to understand. I mean, if I can sort of add up to this, I have actually wanted to understand how would you rate the current legal system's drive towards encouraging access to justice, and if that also involves the virtual proceedings.
I see. Okay. So I mean, it's sort of a segue. We're talking about access to justice generally. The problem with the traditional access to justice has never been the ability of a litigant to attend in court, right? Never. In fact, you would argue that the people who are most likely to need legal representation would in any case be unable to attend a virtual proceeding, right? Because maybe they don't have the resources to do so. So to that extent, remote hearings, remote proceedings, that's not going to help. Right? I mean, that's my view. What is really needed, and especially in Singapore, in my opinion, is an office of the public defender. So the legal industry in Singapore, legal profession in Singapore has taken steps to increase access to justice by making the top firms, but having top firms like Raja and Tan, the biggest firm, in the biggest local firm in Singapore, start up a whole division called Legal Basics, and what they do is they do volume work. They do it for anybody who needs it. The money is still there, right? But they are able to keep their fees down, and have lawyers, top tier lawyers, on everybody's case. So that's one fantastic way of increasing access to justice. But if you're talking about government measures or non private sector measures, like I said, it would be the Office of the Public Defender, something similar but not exactly the same as in the US, because public funds should be going towards, in my opinion, ensuring justice. And that's not just only that's not only from the perspective of, all right, I'm going to make sure that my public prosecutors, they hire the best people to be deputy public prosecutors, or we make sure that the judges are from really respected firms, in private practice, or excellent civil servants. I mean, that's one way for sure, and we have done that. So I mean, lots of respect to the people in the Attorney General's chambers and the prosecutor's office, and to the judges. I think our judges are, forgive me for saying this, but I think they're the best, in Asia. But what we're sorely missing is an expansion on what is currently known as the Legal Aid Bureau, or the Criminal Legal Aid Scheme, or Legal Aid Scheme for Capital Offences. So these are the three typically large ones. What happens there is that we tap upon private practitioners to do pro bono work, which is great, right? And I'm personally involved in both Legal Aid Bureau as well as Criminal Legal Aid Scheme. Haven't quite summoned up the courage to do capital offences yet, but maybe one day. But it at the end of the day, it relies on the goodwill and time of private practitioners, and of course, people who are doing pro bono in any case would never really ask for any compensation or require any remuneration of any sort. But that also puts a cap, realistically, on the amount of pro bono work that you can do, because you can't be working for free. I mean, the firm still expects you to hit your billable hours. And that's just capitalism, right? That's just the natural business process. So to have a dedicated office of the public defender where the floor, or rather, sorry, not the floor, the ceiling on the income required to qualify for public aid, I think, you know, it needs to be raised dramatically. Right now, I think it's far too low, and you know, a lot of lower middle class individuals or even middle class individuals are caught in this really awkward position where they can't afford lawyers, you know, to fight their case for them. But at the same time, they don't qualify for legal aid. So you know, bridging that gap is important. Yeah, if you ask me where the public funds are going to come from, the truth is I don't know. But maybe that's why I'm not a policymaker. You know, it's just an idea that Office of the Public Defender should be something that is readily available for anybody who wants it, because the right to counsel is paramount.
I mean, this was the most brilliant answer I've ever heard of this question, because you see, when you said that the middle class is somewhere in the middle, and that is the maximum population that everyone has, you know, not just in
Exactly.
your side of the world, but in my side of the world. And that's where there's a gap in justice, and we generally forget that. Even there are a lot of data that says all of it. See, pro bono works. I mean, pro bono is all about giving it back to society and adding more value. But as you mentioned, capitalism also exists, and we
Yeah.
have to work for that. That's how business works. So yeah, hope someone out there is listening to you. And as you said, you don't know where the money is coming from, because, and that's the reason you're not a policymaker. But who knows? One day.
Yeah.
Brilliant, David. This has been a great conversation. I have a few more questions for you, but before that, I also wanted to understand. See, your answer seems to be pretty different and interesting. So I want to go back a bit, go back uh, to how, or I should just ask you why legal fraternity? Why not something else? What sort of drove you to this place?
Okay, I'm going to be super candid here. I didn't know what I wanted to do. You know, after high school, essentially. But a lot of my family members are legally trained. They're not necessarily lawyers. Several cousins. My uncle was essentially the head of the state courts. You know, the chief judge of the state courts at some point. Actually, for a long time. My older brother is also a lawyer. So I mean, I thought, and actually, you know, sorry, I mean, a little segue here. I have since been proven wrong, but I thought at the time that the law degree was an extremely versatile one. Now, what I've come to learn over the last, you know, however long it's been since I graduated, 9-10 years, lawyers aren't very good at very much except for the law. Or at least I'm not. You know, so yeah, it teaches you how to think, it teaches you how to analyze, and that could be useful in certain sectors, yes. But it requires, I mean, the most that you're going to learn, you know, in terms of a degree, the most that you're going to learn is the way to process information, the way to process reasoning, to reason things out, and so that's valuable. But you're not going to, most of what you're going to learn, and I'm sure most practitioners will agree with me on this, is on the job. Right? So there's nothing better to teach you than actually doing a job. So you're asking me why the legal fraternity. The truth is I didn't know what to do. But what I can say is that I have learned to love it over the last, you know, 8 years that I've been working, 7 years as a qualified lawyer. I've learned to love it because it's exciting. You know, it's exciting work. You're breaking new ground. There are interesting disputes. You kind of get to learn how the whole world works. Okay, maybe that's a little bit of a naive view, but a lot of how the world works, the finance world. You know, you go from, I mean, the range of clients that you get, especially in a boutique firm like mine, the range of clients you get international banks, right, all the time, fighting with, you know, their clients, and you also get, on the flip side, the common man on the street who's fighting with the international bank. So, you know, it's really fantastic in terms of the type of people that you get to interact with. You get the super sophisticated general counsel, the really savvy businessmen, and also on the other end of the spectrum, you get, your auntie or uncle who just needs help because, their neighbors, have caused lots of problems for them by blocking up their corridor access or something like that, and the way that I like to see it is that lawyers are there not to be obstructive, and that's something that I live by in my practice, especially with opposing counsel, because what you're supposed to do is to facilitate justice. And yes, and people often forget this. The duty is foremost to the court, not to your client. So the facilitation of justice with existing laws, or to argue in such a way, or to make a case in such a way that an ambiguous law can be read the right way to facilitate that justice. That is why I think I stay in the legal fraternity. Which is a slightly different answer from to why did you choose the legal fraternity in the first place? My answer to that is that I think most practitioners choose the legal fraternity every day because it's not easy. Yeah,
that's right. That is again a brilliant answer. I mean, as you very rightly said, it's all about exposure, and once you get it, you start liking it. It becomes your bread and butter and your value addition, and give the way you can give it back to society. And as you said that, I mean, it's your point, of course, no offense to any lawyers, because it's a platform for lawyers. As you said, lawyers are generally good at law. I mean, nothing else but law. Maybe they are good at, I mean, they see everything from inside out. And my father always says that neither get a lawyer as an enemy or as a friend, because they both can be dangerous to you. So, I mean,
it's not wrong.
I'm not okay, I guess it's the same saying there then. So now I now understand that you see a more practical vision of everything, and you understand things from inside out. As you said, in a boutique law firm, when you have exposure of all sort of things from corporates to a middleman, this bridges a lot of things in your understanding, and this is what is reflecting in this session, David. All right, so to move ahead, you said that you have graduated in, like, it's been 9-10 years. So I would say that you are a lawyer of my time. I mean, like, after graduation, you're a lawyer of my time, and our time is all about technology. We saw a lot of disruption, and pandemic ironically worked as a catalyst for many of those things. And same goes with legal tech. So my question is, what are the most commonly used tools for you in the era of legal tech?
Okay, so that would be knowledge management for sure. So databases of precedents, that's important. Every lawyer would know that a precedent is just a piece of paper, right? But it gives you a starting point, right? So how much time does that save? As opposed to you're working on a set of pleadings, and yeah, I've done it before. I've made a case in unjust enrichment before, for instance. But it still saves you that 20 minutes, half an hour for you to think about, all right, these are the elements I need to think about. Those precedents are invaluable. So not just the form of it, but also, the way that my firm works is that our knowledge management system also tries to keep up with the cases which support those propositions. So for instance, if a precedent says you need to plead A, B, C, D, it'll set out that case somewhere. There'll be a note somewhere which says, all right, this is the case which says that, which helps, right? So definitely in terms of knowledge management, that's the most important thing. For very esoteric questions of law, all the research notes are all in one place, and it's all organized very neatly. So to me, that database and the ability to manipulate and search that database easily, that's really important. So that's the most commonly used piece of legal tech for me. Apart from that, I would say it is the same as any other profession. And when I say that, I mean, just being able to keep everything on a cloud, to work anywhere in the world at the snap of a finger, even on your phone or whatever mobile device you're using, to be able to pull up, files from your server because you're connected to the cloud. that is incredible, because it also means that, look, if I don't need to be in the office, I'm not going to be in the office, right? What does that give me time for? That gives me time for, and the number one thing in this is family, because I think gone are the days when you would pore over documents sitting at your desk with stacks of boxes of documents, taller than you, because everything's on the cloud now, and it can be on the cloud, and the ability to quickly upload everything onto the cloud, that's made such a huge difference. And the strides that technology has made in terms of a user-friendly experience for cloud technology. Like, I mean, I'm not being paid by them here, but OneDrive, for instance, or SharePoint, the ability to work simultaneously on a document with associates or your fellow partners, that is invaluable to me. Yeah. Maybe I don't know, maybe I'm scratching the surface, but these are the really key ones.
I mean, brilliant. I guess we have a lot more. I mean, we don't think that we should talk about email management softwares and contractual. I guess there are some in India, at least, there are a lot of startups that are coming with legal tech, involving that, because they say that now it's the need of an hour and people really need it. So that's a great part. My last question to you, David, was actually about time management. You see, but I want to twist it sometime. So I want to put it that way, that you see, we generally see a lot of cases, as you said. If it's from a corporate standpoint, that's maybe a different take. But when it's from a humanoid standpoint, from a common man standpoint, the case generally remains in our head, even when you're not in office, when you're having your lunch, your dinner with your family. How do you make sure that it's not there? If you understand, if it makes sense, the question makes sense. And the last thing is, in that, how you also manage time for you, for your work, and for your family.
Yeah. So I mean, my firm has been very good with flexible working, since the start of the pandemic. Yeah, we're still, required to be in the office for every other week. But, the ability and that flexibility to say, okay, if you need to take your kids to the doctor or whatever it is, it's there for you. Right? Because at the end of the day, what is most important is are deliverables. Yeah. So, from that perspective, the pandemic, as horrible as it's been, has been a great catalyst for change in terms of how people work. So that's helped the legal profession as well, obviously. If you're asking me about how I make my best time as a lawyer, I would say that having specified shutout periods is, so barring something like an injunction or super urgent meeting or something like that, having specified shutout periods of your day is really important. And I'm privileged in that respect, because I'm in that position. I think maybe younger lawyers are not, but that I'll get onto that in a moment. For partners, typically, or associate directors in my case, if you have that specified shutout period of, say, 6 to 8 p.m., that's family time for me. I'm not going to touch my phone. And people in the office know they're not going to touch your phone, right? And everybody understands. That really helps, because it's time with your family. It's really important. And that you set aside, all right, Saturday morning, I'm going to bring my kids to the park, or I'm going to bring them swimming, something like that. That is going to be the key. I mean, of course, work is really important. So if there's something really urgent, we should be doing it. But generally sticking to that specified time is really important. Now, I'm going to backtrack a little bit. I think that applies for people who are in a little bit more senior, right? So because you have that ability. For juniors, I think the thing that I will caveat this entire section with is that hard work is expected. It's still expected of partners, right? But to some degree, even more so as a junior, because you're learning, right? You're going to take more time than a senior person to go through the same document. You're going to spend more time doing the research because you don't know where to look. You're going to spend more time drafting because you're not used to it. So that's where the excess time goes. See, the excess time goes to learning. And I would say that in that respect, that is still making the best of your time as a lawyer. You're still improving yourself. But to sustain that, what do you really need to do? One of the most important things, in my opinion, and I practice this with my associates, is to be able to speak freely with your bosses. Because and I know it's not easy, but try and find a place which allows you to do that. Also, or rather being able to have a frank conversation with them to say, all right, these are the things that you can expect of me, or rather, these are the things that I think I can accomplish today. That sets the expectations for the partner, right? And importantly, having a partner who's understanding, who's not going to yell at you if you don't do that, and understands if you need more time, because again, everybody's been a junior before, right? Every senior partner has been a first-year associate before. They should understand. They should understand the pressures that they've got, that juniors have gone through. And so finding a place which suits your working style, which suits the ability to work at your pace, that is really important. And if that means giving up some of the fame and the glory, and with that, some of the remuneration, I think building a sustainable legal career is more important than going for all of that glitz and glamour. I mean, that's my take on it.
I mean, again, wise words from a wise man. This has been a lovely session, Mr. Lee. I really enjoyed it,
Right.
and I hope you also did. I mean, I also wanted to sort of ask you. This is just the last thing.
Sure.
So the last bit of the part is where can our viewers really find you? Because I guess I'm not done with you. I want to do this for like hours and hours, and I guess same for our viewers. So where can our viewers get a hold of you?
Sure. I mean, I'm sure the creators will make my email address publicly available, my firm email address. But I mean, otherwise, LinkedIn. I think there's only one David Marc Lee, if I'm not wrong, spelled that way anyway. So I'm always open to chat. I'm very happy to share my views, or to hear contrary views, on legal matters, on personal matters. I think the two of them need to work in tandem. The legal mindset of every practitioner needs to work in tandem with the human aspect of us, because if not, we're just robots essentially. So I'm very happy to hear. Yeah.
Brilliant, brilliant. David, thank you very much for your time for the session, and we'll make sure that we mention your LinkedIn's handle or the ID in the description, so that all the viewers can really find you and sort of get a hold of you and bombard you with a lot of questions if they have any or to know about you even further. So thank you very much for sharing
Thank you for your time.
such great insights with us, and we look forward to having a great chat with you again in the future on some other trending topics in the international legal industry. So thank you very much for the session.
Thank you. Right.
Thank you very much. And for our viewers, if you like this chat with David, I want you to click on that like button and like this video, share this video, and subscribe to ClickAway Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders like Mr. David Marc Lee. This was Sagar for LexTalk World signing off.